This training has been designed to provide a basic understanding of what data breaches are, what the General Data Protection Regulation says about them, and how we should deal with breaches if they occur.
It is not a comprehensive guide, rather it is designed to give a basic understanding, and to provide a consistent template for dealing with them should they occur.
Along with this training, AIM offers a range of GDPR and data protection courses, as well as consultation services, tailored to your needs.
Please visit our website, aimltd.uk, for more information.
The session objectives are to understand principles defined in the GDPR, tools provided by the GDPR to manage the risk of breaches, the types of breaches, what the GDPR says about data breaches, the potential penalties for failing to manage a data breach,
our responsibilities regarding breaches, controllers and processors, company policy, breach procedure, and finally, wrap-up.
GDPR principles. The General Data Protection Regulation, GDPR, came into force on the 25th of May 2018. It replaces the Data Protection Directive, 1995, and was immediately enforceable in all EEA jurisdictions. The GDPR has principles, data subject rights, and significant penalties for non-compliance. Consequently, it is important that organizations understand their responsibilities, and in particular, how to deal with data breaches. Note, UK data protection is governed by the Data Protection Act, DPA, 2018. The DPA uses the GDPR as the basis for the regime applicable to the personal data processing completed by UK companies. Consequently, this training is based on that legislation. The GDPR states that data should be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing, and against accidental loss, destruction or damage, using appropriate technical or organizational measures, in order to safeguard the rights and freedoms of the data subject.
GDPR mechanisms, tools. The GDPR does not give any explicit methods of achieving this, but does define two mechanisms, tools, to assist in the design and assessment of processes and systems, which will help organizations comply with Article 5.1f. Data protection by design and default, Article 25. Risk assessments, Article 35. The GDPR recommends a review of the data used in a process, during planning for the implementation of the process, and when the process is live. The measures to be used to protect data in any process or system will be determined by the process owner and IT security. All data transfer methods should be detailed in the process documentation. If data is to be used or transferred, and no process is in place, there is a risk. In this case, it is essential to check with the owner and IT team to establish the best approach. All systems and processes should be subject to a risk analysis, which is documented and retained for evidence in the event of a data breach. Simple assessment. A simple assessment of the likely risk to personal data and the rights and freedoms of the data subject. If this assessment indicates a high risk, for example if there are new technologies, there is large-scale processing of data, processing of special categories of data, or automated processing of data, then a DPIA needs to be carried out. Data Protection Impact Assessment, DPIA, describes the nature, scope, context and purposes of the processing. Assess necessity, proportionality and compliance measures. Identify and assess risks to individuals. Identify any additional measures to mitigate those risks.
What is a data breach? A gap in a wall? Something I wear? Breaking a law? A type of tree? The answer is breaking a law. Whilst a breach can be seen as a loss of data, more generally it relates to the breaking of a law, be it statute or common law, or the rules laid down by an organization.
Types of breach. Typically, we think breaches occur when a cybercriminal hacks our personal data, but they come in many forms. In each case, the breach can be either accidental, or unlawful, and be instigated from either inside, or outside, an organization. An accidental breach is when a human or unintentional error is usually caused by an internal person, or system. An unlawful breach is when an internal or external person maliciously breaches data. So what types of data breach are there? Loss, destruction, alteration, unauthorized access. Examples of data loss. In 2016, Uber concealed a hack that affected 57 million customers and drivers. The breach was hidden, and the firm which paid hackers $100,000, £75,000, to delete the data. The company's former chief executive knew about the breach for over a year. The breached data included names, email addresses and mobile phone numbers. Within that number, 600,000 drivers had their names and license details exposed. Uber were fined $148 million, US breach. The ICO fined Lifecycle Marketing, Mother and Baby, Limited, also known as Emma's Diary, £140,000 for illegally collecting and selling personal information belonging to more than 1 million people. The data broking company, which provides advice on pregnancy and childcare, sold the information to Experian Marketing Services, a branch of the Credit Reference Agency, specifically for use by the Labour Party. Experian then created a database, which the party used to profile the new mums in the run to the 2017 general election. Examples of data destruction. A HR firm's database containing third-party data is corrupted, and no backup is available. This could impact critical processes, for example payroll, and data subjects' ability to raise, or defend, legal action, etc. A pension administration company shreds archived paper documents, relating to deferred DB pension scheme. There is no other material which documents scheme members, accrual, final salary, etc. This would mean data subjects could potentially lose the right to their pensions, or the trustees would be unable to defend a claim from a potential deferred pensioner. Examples of data alteration. A disgruntled employee decides to amend customer personal details on an organization's contact database. This could lead to data subjects receiving incorrect communications, or data intended for other customers. An employee receives personal data in a spreadsheet. They complete some checks which involve sorting the data. They sort a subset of the columns, and then upload to the main database. This data has been altered, in other words breached, and cannot be used. As part of a security strengthening exercise, a company removes a number of personal data fields from an HR database. However, the data was required, and must be refreshed by the data subjects. Examples of unauthorized access to data. The Independent Inquiry into Child Sexual Abuse, IICSA, has been fined £200,000 by the ICO after sending a bulk email that identified possible victims of non-recent child sexual abuse. On the 27th of February 2017, an IICSA staff member sent a blind carbon copy, BCC, email to 90 inquiry participants telling them about a public hearing. After noticing an error in the email, a correction was sent, but email addresses were entered into the to field, instead of the BCC field by mistake. A former employee of a Milton Keynes Hospital Trust has been prosecuted for accessing patient records without authorization. Michelle Harrison, of Milton Keynes, inappropriately accessed the records of 12 patients outside of her role as receptionist/general assistant. In the orthotics department at Milton Keynes University Hospital, NHS Foundation Trust, between March 2016 and January 2017. These included the patient records of her ex-partner and a woman who claimed that Ms. Harrison had used the information to harass her, and had complained to the trust. In summary, a personal data breach is a breach of security, leading to the accidental, or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to, personal data. Recitals 85 and 87, Articles 4.12 and 32.2. This is irrelevant of the immediate impact on the data subject, meaning even if their rights and freedoms have not been compromised, and they have not suffered a material loss, it is still a breach, because unless it is mitigated in some way, the data subject could be disadvantaged in the future.
Penalties. The ICO have assured businesses that financial penalties will not be the primary sanction in the event of a breach, or other issue, and that they will consider alternatives first, for example audits, warnings, reprimands and enforcement notices. But where organizations persistently, deliberately or negligently flout the law, penalties will be applied. There are two levels of fines. 4% of annual global turnover, or €20 million, whichever is the larger, for not applying the GDPR principles, or data subject rights, and not complying with the regulations on international data transfers. 2% or annual global turnover, or €10 million, whichever is the larger, for data breaches, and all other non-compliant activities. The lower fine for a data breach is a recognition of the difficulty of stopping malicious breaches occurring, even if you have taken all reasonable precautions. However, if you have not made any attempt to mitigate the risks, the high level of fine will apply.
Controllers and processors. Data controllers and processors have access to personal data, and as we have seen, substantial fines can be levied for data breaches. But who is liable? A data controller determines the purpose and means of processing personal data. A processor processes data on behalf of the controller. The GDPR makes both the controller and processor potentially liable to penalties if there is a data breach. Key points to note. Regardless of where the breach occurs, it is the responsibility of the data controller to report the breach to the supervisory authority, ICO. The ICO can communicate with both the data controller and processor. The ICO can impose fines on both the data controller and processor. The old Data Protection Act used to penalize only the data controller. Data subjects can make compensation claims separate to the ICO fines. It is essential that data controllers complete full due diligence on data processors prior to engaging them, and they audit the processor regularly. Data processors need to be an active participant in data management and security. The following diagram and notes show the relationship between the data subject, controller and processor.
Prison sentence as a result of unauthorized data access. The penalties described previously are defined in the GDPR. However, data breaches can be prosecuted under other areas of the law. Here's an example. A motor industry employee has been sentenced to 6 months in prison in the first prosecution to be brought by the ICO under legislation, which carries a potential prison sentence. Mustafa Qasim, who worked for accident repair firm Nationwide Accident Repair Services, NARS, accessed thousands of customer records containing personal data without permission, using his colleagues' login details, to access a software system that estimates the cost of vehicle repairs, known as Audatex. He continued to do this after he started a new job at a different car repair organization which used the same software system. The records contained customers' names, phone numbers, vehicle and accident information. NARS contacted the ICO when they saw an increase in customer complaints about nuisance calls, and assisted the ICO with their investigation. The ICO usually prosecutes cases like this under the Data Protection Act 1998 or 2018, depending on the individual case. However, in appropriate cases, it can prosecute under other legislation. In this case, S.1 of the Computer Misuse Act 1990, to reflect the nature and extent of the offending and for the sentencing court to have a wider range of penalties available.
Data breach prevention. How can we prevent data breaches? Whilst there is no single way to eliminate the possibility of data breaches, there are actions we can take to reduce the likelihood of a breach. Maintaining a clear desk policy. Locking computer, laptop when unattended. Not sharing user credentials. Not accessing data unless it is part of our role. Not sharing work-related information with our family and friends, or on social media. Not making multiple copies of data and saving it in multiple locations. Not using USB storage devices. Not using personal email accounts. Not using personal devices, for example, laptops, to complete work-related tasks. Not sending personal data by email. Use a secure file transfer protocol or alternative. Not leaving laptops, phones, storage devices or paper files unattended outside the office.
Data breach procedure. If an organization has a data breach, the GDPR describes its responsibilities. It also defines the key elements to be included in the organization's breach process. There is a duty for all organizations to report personal data breaches to the relevant supervisory authority within 72 hours, where feasible. Article 83. If the breach is likely to result in a high risk of adversely affecting individuals' rights and freedoms, you must also inform those individuals without undue delay. Article 84. Organizations should ensure they have robust breach detection, investigation and internal reporting procedures in place. Article 33, 1, 2, 3. You must also keep a record of any personal data breaches, regardless of whether you are required to notify. Article 33, 5. In the event of a breach, there are a number of activities that need to take place. These will be documented in the organization's policy, and will include the activities listed on the following slides. All data breaches, regardless of scale, should be reported to the Data Protection Officer, DPO, or a line manager, or director, if the DPO is not available, or if your company doesn't have a DPO. No member of the organization should make any decisions about the scope, severity, or follow-up actions relating to a data breach, without first informing, and then receiving, input from the DPO, or a senior director. From the moment you know about the breach, you have 72 hours to 1. Report the breach to the ICO if personal data was impacted, mitigating actions were not in place, and there is a risk to data subjects' rights and freedoms. 2. Inform the data subjects impacted by the breach, if there is a risk to their rights and freedoms, or there might be a lasting legal or financial impact. 3. Put mitigating actions in place to reduce the risk to the data subjects. 4. Determine future actions along with a timeline for completion. If it is not possible to collate all information in the initial 72-hour window, you must inform the ICO, and provide contact details of the responsible person, and a timeline for submission of the final report. It is an organization's responsibility to document data breaches, and all subsequent actions, in a data breach log. The DPO, or Data Protection Lead, will manage this activity. Determining if we need to report the breach to the ICO, or data subject, require the organization to know the nature of the data breached, and the risks posed to the data subjects. This is not always as easy as it might seem. For instance, data that has been deleted, with no backup in place, can be hard to reconstruct. Data held on a removable memory device will almost certainly have been downloaded on an ad hoc basis, and establishing the nature of that data will be very difficult. Unauthorized access and export of data may leave an audit trail, but this is not guaranteed. Note on the 72-hour reporting window. The 72 hours start from the time the breach is identified. The 72 hours are continuous, not working days, i.e. you have 3 days from the breach to inform the ICO. If the breach occurs at 2 p.m. on a Friday, the report must be submitted by 2 p.m. on the following Monday. This means that the investigation will need to take place over the weekend. In employee and third-party supplier contracts, it must be clear that in exceptional circumstances, for example a breach, out-of-hours and weekend working will be required. If a full breach report is not possible within the 72-hour window, a preliminary report must be submitted, with details of the follow-up actions and timescales. When informing the ICO and data subject, it is important to provide clear information, and detail the ways in which the organization is mitigating the risk to the data subjects. Mitigations might include resetting passwords, putting accounts on hold until checks have been completed, providing safeguards, for example free access to credit rating services for a period of time. There are 3 key elements in detecting and responding to data breaches: embarrassment, resources, time. Embarrassment. If I have made a mistake, especially one which was easy to avoid, or has caused a significant breach, I may be tempted to look the other way and hope it all goes away. Whilst this is possible, the repercussions, should the breach be discovered at a later date, especially if it adversely impacts other data subjects, are huge, and could have a major impact on all employees. Consequently, raising it immediately is imperative. Remember, everyone makes mistakes, and speaking up is a positive action. Resources. The DPO, or Data Protection Lead, will coordinate the response, but individual tasks will be allocated to other team members. The determination of the data breached, risks, and mitigations are to be managed by subject matter experts, or third-party coordinators. The management of breaches must be seen as a priority, superseding almost any other activity, since the determination of risk is key to protecting data subjects. Time. There is not long to make the initial determination and report to the ICO, if necessary, hence, speedy identification, escalation and cooperation during the investigation are key. Data breach summary. Discovery, 72-hour reporting window starts. DPO, inform the data protection officer, line manager or director. Investigation, involve internal teams and third-party providers, processors, to determine if the breach needs to be reported to the ICO and data subject, establish mitigations and put actions in place. Initial ICO report breach to the ICO, or log on the organization's breach log if an ICO report is not required. Inform data subjects of the breach, if required, explaining the context, data breached and actions put in place to safeguard the data subject. Follow-up actions, document the follow-up actions required and plan for implementing any changes. Final report, only required if the initial report did not contain a full description of the breach, mitigations and follow-up actions.
Data breach resources. If a data breach has occurred, there are 2 resources that can assist in understanding how to proceed. The first are company policies, which will provide escalation routes, actions to complete, and further guidance. Secondly, there is guidance from the Information Commissioner's Office, ICO, which gives a generic view of the actions to be taken. There is a dedicated page on the ICO website where you will find an online form. Or it is possible to report breaches by phone, 0303 123 1113, from 9 a.m. to 5 p.m. When called, the helpline will request the following information: what has happened, when and how you found out about the breach, the people that have been or may be affected by the breach, what you are doing as a result of the breach, who we should contact if we need more information, and who else you have told. The last question is important in that it assumes a risk assessment has been completed, which shows whether there is a higher risk to the data subjects, and consequently, there is a requirement to inform them of the data breach.
Non-personal data breaches. Data breaches do not only occur with personal data. Everything in this training material relates to non-personal data, as well as personal. Any action which destroys, loses, alters, or allows unauthorized disclosure of, or access to data, regardless of the type of data, is a breach. However, non-personal data breaches do not need to be reported to the ICO, although they still need to be reported internally to a director, or your line manager. It may not be immediately obvious, but non-personal data breaches may be as devastating to an organization, or group of individuals, as losing personal data. For example, sending a batch of invoices to the wrong client may raise questions regarding pricing and future business, which may significantly impact the profitability of the company, and, as a result, impact employees who work on that client's account. In addition, it may bring the company into disrepute, leading to a loss of future business, further damaging the company's ability to trade. At all times we must be aware of the danger of data breaches, and escalate their occurrence as soon as we become aware of them, regardless of the origin of the breach.
Wrap-up. Data breaches are serious. They must be reported and investigated immediately. They are a priority. They can cause significant financial impact to a company. The same rules apply to any data loss, since they may impact the company, or a group negatively.
We will now ask you a few questions. Some time will be left for you to think about the answer, however, feel free to pause the video after the question is asked, to allow yourself enough time to think about the answer. The question will be answered shortly after. What is a data breach? Select all that apply. A data loss. Data being stolen. Unauthorized access to data. That's right. All of these are data breaches. Any action that results in personal data being lost, accessed, amended, or viewed without authorization, is a breach.
How long after a breach is identified must it be reported to the ICO? 1 day, 3 days, 7 days, 28 days. Breaches must be reported to the ICO within 72 hours, so 3 days.
If a breach does not need to be reported to the ICO, what actions are required? Data subjects need to be informed. A full data inventory needs to be completed. All directors need to be informed of the breach and the actions taken. The breach must be logged in the data breach log. If there is no reportable breach, either the data is not personal, or poses no risk to data subjects, then the only action required is that it is logged.
If a data breach poses a high risk to the rights and freedoms of data subjects, what must the organization do? Inform the police. Inform the data subject. Immediately erase all data subject data. Make a goodwill payment to the data subject. The data subject must be made aware of the risk. The police do not need to be informed, unless criminal activity has been involved, and any financial recompense to data subjects will be determined at a later date.
Congratulations! You have completed the data breach training.
Feel free to come back to this video whenever you want to refresh your knowledge on data breaches.